Good. So why don't we just begin with introductions and then I'll talk about how we had planned to proceed. So I am
Perfect.
Safier. I am a lawyer at the law firm Ballard, Spahr in Philadelphia, and my practice is concentrated on media law, defending media companies that have been sued for defamation, invasion of privacy, and the like, and pursuing access to records and court proceedings. Melissa?
Hi, folks. My name is Melissa Melewsky. I'm in-house counsel with the Pennsylvania NewsMedia Association, and in that role, I wear many hats, including as a registered lobbyist. So I oftentimes am in the room when some of the laws you're going to hear about today are being debated and discussed. And another one of the hats I wear is as the legal hotline administrator. If you have a legal question, if you're a PNA member, a member of the press, you can call me, email me, contact me, and I will give you an opinion on media law and how it impacts your job. Most questions I answer have to do with public access, First Amendment, statutory rights to records and meetings. But I answer around 2,000 calls a year, 2,000 inquiries a year. Most of them are email at this point. So I hear about it all. And folks don't call me with things when they go right. They call me when things go wrong. So I'm a wealth of knowledge as to how things shouldn't work. But I would love to hear your examples of how they're really working well.
And Judge Beadlestone?
Yes, I'm Chief Judge Beadlestone of the Eastern District of Pennsylvania. In talking with Melissa and Paul yesterday, they asked me to tell you about my experience as a journalist. I was a TV news journalist for 6 years before I became a lawyer. I started off with the BBC in the United Kingdom, was lured over here by CNN when it was still a fledgling network. And from there, I went to various TV stations and ended up here at WCAU in Philadelphia. Once I went to law school, I really wanted to do First Amendment work because it's exciting and because I had been a journalist. So I went to my first law firm and engaged with the partner there who did First Amendment work. So represented the New York Times, the Philadelphia Magazine, NBC, various organizations for a fair while I was in practice. Had a tremendous amount of fun doing that.
Great. So we'll begin. So the way we had planned to set this up. Oh, Deborah, are
Wait,
you?
Your Honor, you stopped at the being a lawyer.
Oh,
We need to continue your history.
Well, I was a lawyer, did a lot of First Amendment work, and all sorts of other complex litigation. Then I went off to become general counsel of the school district, which was interesting because my boss, Paul Vallis, decided that I was very good at dealing with the media, and here is what he did. And I don't hope I'm not telling stories out of school. He would bring in journalists into his office and talk to them literally for hours about a particular issue. And he would say, this is strictly off the record, and if you say anything in the article about what I say here, you will never come in again to my office. But he would say, he would actually say General Counsel Wendy Beadlestone, and I would say, that's not my job, you can't make me do this, but he would anyway. And he would suddenly turn to me and say, so Wendy, what can they say? And then my job was to sort of spout the soundbite. And sure enough, the next day the soundbite would be in the paper. So not a good practice, but nevertheless, he was my boss, and that's how he used me. And then after that, I went to another law firm as a partner, and then to the federal bench. That good enough for you, Debbie?
Yes, thank you. I knew we had to share a little more. Thank you.
I enjoyed the cliffhanger. So the way we decided to proceed here is I'm going to talk briefly about some of the First Amendment considerations and principles governing the rights of the press in courtrooms and their environs. Melissa then is going to expand on that, focusing on some of the practical considerations in terms of how to know what your rights are in particular proceedings and how to assert them. And then we plan to spend most of our time, and most interestingly, interviewing Judge Beadlestone about her experiences and her views on these subjects. So just to begin, so the rights that journalists have with respect to courtrooms are both very strong and somewhat weak. They're very strong in the sense that there is a well-established right under the First Amendment and the common law to be present in a courtroom and observe trial proceedings. I won't bore you with court citations, but starting in the 1980s, this US Supreme Court came out with a series of decisions that made clear that there's a presumptive right owned by the press and the public, rooted in the First Amendment, to public access to trial proceedings. And the core basis for that right was the idea that even going back to colonial times, trials had always been public. You know, our legal institutions are public institutions, just like our other governing institutions. And it's extraordinarily important that the public have the right to sort of understand what happens in our courts and monitor what goes on there. From that sort of core understanding that trials are public, the rights to access then get expanded to most trial proceedings, and at least major trial proceedings, and a number of sort of the most court filings. So where that all lands is that there's a presumptive right on the part of the public to access court proceedings, to literally be present in the courtroom, and in most cases to sort of get access to materials that are filed in court. There's some exceptions. Minor proceedings like status conferences aren't necessarily open to the public. Discovery proceedings usually aren't open to the public because discovery is considered sort of a somewhat different animal where parties exchange information that isn't necessarily hasn't been established or adjudicated to be relevant to the actual proceeding. But the basic rule is that courtrooms themselves and materials filed in conjunction with court proceedings are presumptively available to the public. What that means is that before a proceeding can be closed, at least two things have to happen. First, there has to be notice given to the public that there is going to be a proceeding closed and an opportunity to object to the proceeding. And then there have to be findings on the record made by the court that under the particular circumstances of the case, closure is necessary to protect an interest of the highest order. There is, you know, in terms of actual access to a court proceeding as opposed to a court record, it will very rarely be the case that closure or sealing is legitimate. There have been some arguments in the national security context that proceedings can be closed to the public, but it will very rarely be the case that a courtroom can actually be sort of, you know, shut down and completely sealed off. So the bottom line here is that there's a very strong right to be literally present in a courtroom. And this can sort of expand into sort of related rights, or there are ways in which courts accommodate that right. So for instance, if there's a very sort of high profile proceeding, there's a concern that the courtroom is going to be so crowded that the press might not be able to get there. Typically courts should and will open up satellite courtrooms with video links. Those video links need to be sort of sufficiently robust that you can really see what's going on. A couple of years ago, I was representing the press in connection with, I think it was the second trial of Bill Cosby up in Montgomery County. So many jurors were brought in, or potential jurors were brought in for voir dire, that there wasn't room for the press in the courtroom. They set up a sort of satellite courtroom with a video link, and we actually went to court and said the video link is not effective enough. We don't get to see the jurors' faces. We should see them, and ultimately we won on that issue. So there's a sense that, you know, you as a journalist have a right to be in the courtroom, and to the extent that there are practical impediments to that, courts should really accommodate that to get you as close as you can to sort of view and see the action. So that's sort of the good news, the sense in which your rights are quite strong. The flip side of that is that when you're actually in the courtroom, restrictions can be placed on what you can and cannot do. I think everyone who's a parent has at some point said to their kids, you know, our house is not a democracy. Something similar is true about courtrooms, right? Courts play an extraordinarily important role in our democracy, but they aren't and cannot be structured in a sort of anything goes, you can say or do whatever you want manner. So as you know from TV, you can do things, you can be subject to contempt sanctions if you speak out of turn in court. And similar sort of rules can apply to the conduct of journalists in courtrooms and what they are or not permitted to do when they're actually in a court. In many, Melissa will talk about this in more detail, but in many courts, you aren't permitted to have phones. In many courts, you aren't permitted to have computers. But this is something that can vary widely. So earlier this year, I represented CNN in a trial that was in Florida State Court. And that proceeding was live streamed on court TV, and anything, you could do anything in the courtroom, essentially, not anything literally, but there were journalists in the back of the room who were on their phones, who were on their laptops, live tweeting, texting with their editors. All of that was permitted. In other courts, that would literally be subject to criminal contempt sanctions if you behaved in that way. So you need to understand, when you're actually in a courtroom, what is permitted in that context. Melissa will talk more about this, but in Pennsylvania State Court, there's an absolute prohibition on recording any proceedings. In federal court, there's a prohibition on recording proceedings and broadcasting proceedings. There have been different court decisions with different courts coming out differently about whether the prohibition on broadcasting is also a prohibition on, live transmitting what's happening. So can you live tweet a proceeding? Can you live blog a proceeding? Those are all things that are going to be determined on a case-by-case basis. So I'll now turn it over to Melissa, but the sort of big takeaway is you have very strong rights to be in the courtroom. But once you're in the courtroom, you need to make sure ahead of time that you know exactly what you can or cannot do.
So thank you, Paul. I'm going to focus today on Pennsylvania courts since that's the focus of my practice. In Pennsylvania, it's important to understand that there are rules of judicial administration, rules of criminal procedure at the state level that govern what you can and cannot do inside of a courtroom as a journalist. And there are also companion rules at the federal level as well. I'll start first by talking about Rule 112, and I'll drop links to these in the chat at some point when I'm done speaking so that you can read through the rules yourselves and have them. Rule 112 of the Pennsylvania Rules of Criminal Procedure prohibits publicity, broadcasting, and recording of proceedings in the courts. Now, this is a rule of criminal procedure. I'm going to talk a little bit about what happens in the civil context and outside criminal proceedings, but ultimately, basically what the rule says is, in essence, is you cannot take photographs, you cannot capture video, no motion pictures of any kind of judicial proceedings in the hearing room, the courtroom, or its environs during a judicial proceeding. That's pretty broad. No, Pennsylvania is a no cameras in the courtroom state. It also prohibits the transmission of these communications by phone, radio, TV, or any advanced communication to technology from the hearing room, the courtroom, and its environs in connection with any judicial proceedings, whether or not the court is actually in session or not. And the environs of the court and the hearing room is defined as the area immediately surrounding the entrances and exits to the hearings rooms and the courtrooms. So if any of you cover court proceedings here in Pennsylvania, you know that the magisterial district courts are oftentimes, sometimes even single or double rooms inside of a strip mall, for example. Like my magisterial district court opens directly onto the parking lot of the shopping center where it's located. Had reporters threatened with violating this, with violating this rule, and there's a companion criminal sanction I'm going to talk about shortly, because they were in the parking lot kind of getting the perp walk as the defendants were being led in and out of preliminary hearings before a magisterial district court. Security at county level courthouses is much different. You have to go through security in order to get into the building, and that's where the different counties and president judges have implemented various rules and regulations regarding the use of and even possession of things like a cell phone, a laptop, or any other kind of advanced communication device, which is sometimes defined concretely and sometimes not. Counties vary widely on how to implement these policies. There are often exceptions to that. So, for example, attorneys and other officers of the court typically are allowed to have their communication devices on them. In some counties, there is an exception for media. In some counties, there are not. For example, if I go to Huntington County as a member of the bar, I'm allowed to have my communication devices on my person, although they have to be completely powered off. If I go into the courthouse in York County, it goes into a locked bag and I can't have access to it. The same rules apply to journalists in the different county courts. So it's, as you're gathering, as you're doing your news gathering, it's going to be really important to do a little bit of research before you start the process so that you understand which county you're dealing with and whether or not they have a rule that's going to impact your possession of your devices in the courthouse. Because you will have to comply with, if you are lucky enough to be into one of the courthouses where you're allowed to retain possession of your devices, you will have to comply with, for instance, Rule 112 that says you may not use it to take photographs, video, or motion pictures inside a hearing room courtroom or its environs during or pertinent to a judicial proceeding. That's on the criminal side, but the general rule also applies to civil proceedings as well, because we have Pennsylvania Rule of Judicial Administration 19.10, which is titled Broadcasting in the Courtroom. And it says, unless otherwise provided by the Supreme Court of Pennsylvania, judges should, not must, but judges should prohibit broadcasting, televising, recording, or taking photographs in the courtroom and the areas immediately adjacent thereto during sessions of court or recesses between sessions, except that they can authorize certain technology for the presentation of evidence or recording of the record for judicial administration purposes. They can also allow in certain situations like investiture, ceremonial proceedings, naturalization proceedings. There can be special exceptions made in those circumstances. And when I clerked for a judge at the common pleas level, it was quite common to have not media, but people in the courtroom who were there for those ceremonial proceedings, snapping pictures the whole time. So there are general, there's some flexibility in Rule 1910, but again, it's generally not extended to a proceeding that is going to be deciding a disputed case. They're generally just for ceremonial proceedings. I also want to mention the fact that in addition to these two court rules, Pennsylvania also enacted a few years ago a crimes code section. Title 18 is where Pennsylvania keeps their crimes. Section 5103.1 is entitled The Unlawful Use of an Audio or Video Device in Court. And it says it makes it a crime for a person to, in any manner or for any purpose, use or operate a device to capture, record, transmit, broadcast, or broadcast a photo, video, motion picture, or audio of a proceeding or a person within a judicial facility or in an area adjacent to or immediately surrounding a judicial facility without the approval of the court or the judicial officer. And that is, in some cases, it can be a felony. So you want to be very careful that you are not snapping pictures in an area or recording in an area where you are not expressly allowed to by either the presiding judge or by a particular local rule of court. On the federal side, Rule 53 prohibits courtroom photography and broadcasting except as otherwise provided by statute. The court must not permit the taking of photographs in the courtroom during judicial proceedings or the broadcasting of judicial proceedings from the courtroom. And that's a federal rule. So again, in addition to understanding what county you're dealing with, you should know whether you're dealing with state court or federal court. The laws are similar, but not the same. The penalties for violation in state court, I think, are going to be, obviously it's a crime under Pennsylvania's crimes code. I don't believe there's a similar statute at the federal level, but Judge, if you know differently, please correct me. What I hear about most when I'm dealing with calls from journalists is once they're in the courtroom, what can I do? Sometimes if you're in a court, if you're in one of the courthouses that allows you to have your communication device, your phone, your laptop, your iPad, the question becomes, can I use it to do something other than take photos or broadcast? Can I use it to take notes, or am I limited to pen and paper? And that's going to be decided largely by the judge that's presiding in whichever proceeding you're dealing with. Sometimes, I think it was an issue in Montgomery County as part of the Cosby trial, the way that courthouse is set up, there are common areas where the press was stationed, and their question was, you know, do these rules that I just explained, do those rules apply in those common areas? Where do we get the perp walk photograph, for example? And I think ultimately, Paul, correct me if I'm wrong, that they were not allowed to take photos within that courthouse at all, but there were places outside the courthouse that the press had designated space where they could get photos and interview people coming into and out of the courthouse.
Yeah, that's right. All the rules about using your phones were applied immediately outside the courtroom, including, you know, with a number of reporters actually being subject to criminal contempt for texting and things like that just outside the courtroom, including one intern who was texting her father about when she needed to be picked up. So
yes, so you want to be very careful and very cautious because there are some significant penalties, including criminal penalties, that can apply if you find yourself using your equipment in a courthouse. With regard to televising judicial proceedings, like I said, the rules generally prohibit that at the state court trial level. At the appellate court level, the AOPC, which is the administrative arm of Pennsylvania's state Supreme Court, they do broadcast on their own in conjunction with PCN, Pennsylvania Cable Network, argument sessions of the appellate courts, the Commonwealth Court and the Supreme Court. So you have access to that via their feed, but you cannot take your own camera into, for example, the Commonwealth Court argument room. I was in the Commonwealth Court last week for, something else, none related to this, and I happened to walk by the Commonwealth Court's argument room, and outside there's a giant poster that has the criminal statute that I just read to you that says you may not take pictures, you may not use your devices, you may not record anything within this hearing room. So you do have to be aware that even though those argument sessions are broadcast and recorded by the court and their partner, that right does not extend to you as a member of the press or as a member of the general public if you were just there to watch. I mean, these are all public proceedings. Oftentimes as the press, you will be one of the few members of the gallery, especially at the state court level. Your communities depend on you to be their eyes and ears. Sometimes there may be a few people, but it will typically be you. And what I tell journalists is, if one of your regular beats is the courthouse, get to know everyone. When I clerked for a judge, the press had in chambers, the press had a box where they would come and pick up the daily orders. We would make 3 copies, one for the defendant, one for the plaintiff or the DA, and one for the press box. And the 2 reporters who were there every day would walk in, they'd get the orders, and they'd walk back out. They weren't asking questions, they weren't getting guidance from the court, but they were getting access to the records that they needed in a timely manner. And it's because there was a relationship of trust that existed between the journalists who were there, 3, 4, 5 days a week, and the courthouse officials, including people in the clerk's office, people in the prothonotari's office, and people in judicial administration. Now, if you find yourself in a situation where you don't know what the rule is, or you have a question about what you can or cannot do inside a courtroom, I would recommend you approach the judicial administration, the court administrator's office, and chambers with a question. The judge may or may not answer it. It's going to depend on the judge, but know what the rules are, know that sometimes there will not be a clear answer to your question, and know that there are resources that can help you. With regard to access to records, and sometimes proceedings as well, if the court at the local level, at the state level, is not capable of or will not answer your question, the Administrative Office of Pennsylvania Courts has a press office that is very good at getting back to members of the media, and they will help you solve your problem to the extent that they are able. And that goes for proceedings as well as records. So it's not unusual for a reporter to call me and say, hey, look, I can see this is docketed. The clerks at the courthouse are telling me either they don't have it, they don't know where it is, or that I can't have it, but there's no seal order. I would say to them, let's reach out to the AOPC and see what they can do. And sometimes that resolves the problem, and sometimes it doesn't, and there needs to be a motion to intervene or other legal action. But a lawsuit and filing something in court should not be your first reaction to an access issue. It's typically going to be, how can I solve this without having to file a lawsuit? And the AOPC's press office is often a very good place to start that informal access process. With regard to kind of things that have gotten reporters in a little bit of hot water, like I said before, magisterial district court offices are oftentimes, they open right onto the street, and the rules say the courtroom and its environs. Sometimes the court rules that you'll see, for example, Lancaster County's court access rule and possession policy is very, very broad. It applies not only to the courthouse, but also to court-related offices. So, for example, it covers the probation office. It covers offices that aren't necessarily judicial in nature, but they happen to share office space with the court. So, for example, it's not unusual to have county-level row offices in the same building as the courthouse or a court-related office. You need to figure out because sometimes there are competing legal rights and limitations that, you may have a right to go into the Register of Wills office and take a picture of a public record, or the Recorder of Deeds office to take a picture of a public record, but you have to have your access to your camera and your phone in order to do that. And if you get stopped at the front door of the courthouse and they say you can't have these things, so you can't exercise those rights in the Recorder of Deeds office, there becomes, there's tension between the court rules and the access rules that apply to the non-judicial offices that happen to share space. In those situations, it's typically the county administrators who can help us work those out. But again, your first reaction is not going to be, I'm going to file a lawsuit. I'm sorry, Paul. It's not going to be to call Paul and file a lawsuit. I mean, there is a time and a place for litigation related to public access, but it's never going to be your first step. So if there's anything, if there's anything you take away from this, is that you will encounter access questions, you will encounter access problems, but I think there are resources, people like myself, people like Paul, the AOPC's press office, there are resources there that can help you navigate those issues. And if they're not resolved, then legal action is always an option. With regard to legal action, if you find yourself in a courtroom, in a court setting, and the parties and the court announce they're going to adjourn to a sealed proceeding, or they're going to have a seal on a particular piece of evidence, there is a First Amendment right to object in the moment, in the courtroom. Now, each judge will handle that differently. And I've had journalists stand up from the gallery and say, I'm John Smith, I'm with CNN. Your Honor, I believe there's a constitutional right to access this proceeding or this record. I would like you to put it on hold, stay your decision or your implementation of this order until I can get counsel and intervene in the case. I have seen judges say, thank you, I appreciate your objection, it's noted, but we're going to proceed. And I have seen judges put the proceedings on hold until the attorney for the media get into the courtroom and can make legal argument. It's going to vary widely, but there you do have a constitutional right to make that objection, even as a non-litigant, because the public, like Paul explained, has significant rights to access records and proceedings. But ultimately, how that right is exercised within the court, within a courtroom during a proceeding, is going to be handled differently by the various judges who are sitting on the bench. Paul, do you want to start the?
Sure. There was one
Judge?
person had a question in the chat about court reporters. You, Melissa, or Judge Beelson, you know the answer. My understanding is that, or not court reporters, court sketch artists. The reason why we have the phenomenon of court sketch artists is precisely because photography is not permitted in the courtroom. So a profession bloomed where people are good at doing courtroom likenesses. My understanding is that any member of the public, they're not, they don't have any special rights, that any member of the public could draw pictures of, of what's happening. And the reason that sketch artists do it is because they're good at it, not because they have any special rights. But I don't know if anyone has any.
I mean, I think I read a case once or a long time ago about the sketch artists being brought in because of this, this constitutional balancing that has to, when you are closing off a right, for example, a right to record or cover a proceeding, there has to be the general standard is you use the least restrictive means, and you have a narrowly tailored remedy, and you leave open alternate channels of communication. I think the sketch artist in this situation is the alternate channels of communication. So you're not letting the camera into the courtroom, but in order to comply with constitutional mandate, that least restrictive, narrowly tailored alternative means is filled by the sketch artist, who do beautiful work.
And there are a number of circumstances where courts have held that the public's right to be present in a courtroom equates to a right to sort of not be there, but learn through other means what's actually happening. So in addition to sort of there being a due process right to a court transcript, often there's a First Amendment right that there be a court transcript. So there's some recording of what happened. So Judge Beelstone, before we get into specific questions, is there anything you want to say or add to what has been said thus far?
Well, I always like to listen to the various bits and pieces of the taxonomy, the world in which journalists operate, and then sort of go high and look at the taxonomy. And the way I think about that taxonomy is There's access and there's actions. What actions can you take once you have access? So access, Paul talked about common law access, First Amendment access. And in some instances, there is some discussion about whether access is the same in the civil or the criminal context. And that's something you have to think about. And then with respect to actions, again, Melissa has been talking about that. There's also distinction between in court, what can you do in court? What actions can you take in court? And what actions can you take in the curtilage of the court? And the curtilage of the court can again be divided up into what actions can you take inside the courthouse and what actions, once you get outside the courthouse, what can you do? And obviously the analysis changes in all of those circumstances. So first of all, I mean, I think you have to know the rules. I think Melissa suggested you call up Chambers. If someone called up Chambers and said, what are the rules? I would say, look, not my problem, learn the rules. And the rules, as we've talked about, are in Federal Rule of Criminal Procedure 53. Again, access, yes, but courtroom, here's a prohibition on the judge. The judge cannot allow courtroom photography and broadcasting in criminal cases. It is something I have no power to do. So again, that's a part of the taxonomy. What is it that the judge cannot do, and what is it that the parties cannot do? And with respect to civil cases, at least in the Eastern District of Pennsylvania, we have Local Civil Rule 83.3, which prohibits courtroom photography and broadcasting in all cases except upon approval by the chief judge for investiture, ceremonial, or naturalization proceedings. So what that says, I would think, is first of all, there are all these joyous occasions that the press can come in or the media can come in and can record. A naturalization ceremony is one of the most heartwarming things you can possibly imagine, as is a ceremonial investiture. People are saying all sorts of really wonderful things about each other, about the process. And actually, I've never seen anyone come into any of those proceedings. So that is something that you can do, which is pure joy, and it is also a noteworthy event. So we've got this local rule 83.3 with respect to civil cases, but we've also got this standing order. And the standing order was effective June the 3rd, 2019. And it really talks about bringing in cameras and personal electronic devices into the courtroom. In essence, generally, people are not allowed to bring them in. There's little pouches. We have the entrance to the courthouse, and your devices must be turned off and put into the pouches. There is an exception for members of the press or media on official business with valid identification from their news organizations. And those electronic devices are allowed to be brought into the courtroom. They must be turned off. They must be not on silent or vibrate mode before entering the courtroom. And every now and again, someone has come in with a phone that is not turned off. And it really disrupts the proceedings because it's any proceeding is always very intense. And if you suddenly hear a buzz or a phone ringing, it shatters the environment in which the judge is trying to do their job. So bottom line, know the rules and make sure that you follow the rules.
So Judge Beaglestone, if you are presiding over a proceeding that you know is going to generate a ton of press attention. So we talked about the Cosby case. A very recent example is the criminal case of Sean Combs in the Southern District of New York. That kind of case where you know there's going to be. Do you make arrangements ahead of time to sort of address that issue? Do you address it on the fly? Is that something that you're thinking about in thinking about the proceeding?
Well, I've had many high-profile cases, but to tell you the truth, there's usually 2 journalists tops in the courtroom. And what happens is they write the story and everyone else picks up the story. So I have not been in a situation where we've got an ongoing case where a lot of press wants to be in the courtroom. I mean, what I would say is that everybody should understand, read all those rules. And there is opportunities to get certain exceptions by going to the chief judge. In that case, in this case, it would be me, but also the clerk of court would be handling things if there was anything particularly particularly noteworthy or particularly interesting to the public. We did have a couple of trials last year, I think. And what generally happens is the press gathers outside, and this is the perp walk thing you were talking about, is the press gathers outside, and as people are walking in and out of the courtroom, they get that perp walk.
During the pandemic, did you make special arrangements to ensure that there was public access to proceedings, notwithstanding the sort of physical limitations on?
Well, so during the pandemic, I moved a lot of my work to Zoom, and there's a couple of there's sort of a break in the kinds of work that I did on Zoom. So there's something called Rule 16 in the Federal Rules of Civil Procedure, which essentially requires the judge to talk to the parties very early on in the game to help them think about scheduling, think about whether there's a possibility of settling, to hash through some of the issues that might arise in the litigation. That had always been, and I think universally in our court, it's in chambers. It has never been open to the public. It's a very open discussion. And it was very easy to have those on Zoom. And in fact, I have those on Zoom now.
And we attorneys appreciate that so much. We appreciate so much not having to travel to the courtroom.
I know, and it saves a lot of money. It used to be that I would have people lined up outside there, outside my chambers, and I would just roll them in, every half an hour. But now sometimes a case will take a long time to think through, and other times it'll take 2 minutes. It's certainly very helpful. But those Zoom conferences are not open to the public. They never have been. They're just conversations, and that's just the way it has been. However, because during the pandemic we did a lot of work on Zoom. For example, I think I did many pleas. I took many pleas on Zoom. I did one sentencing, then I didn't think it was appropriate and stopped after that. I had a lot of arguments, which normally would be held in open court. And in those instances, if a member of the press called up chambers and said, "Can I please access the Zoom?" I would say, "Sure, of course." Obviously, they would remain on mute, just as they would if they were in a courtroom. And obviously, they had no right to engage in a discussion. I think that might be, if I said, okay, press has to be out, there would be that thing that Paul was talking about, and there could be a request to intervene. But generally, there was none of that, none of those situations arose during Zoom, and I had, I wouldn't say I had many members of the press. It was generally in criminal matters, but if they asked, we would give them the Zoom link. Oh, and one other thing, there was actually one, it was a party, not a member of the press, who tried to record the Zoom, and that was not, they did not fare well in front of me when they did that.
Melissa, did you?
I hold them on the carpet, because I think that broadcasting, filming a judicial proceeding, whether or not it's Zoom or in the courthouse, it's still a problem. And if you, I think there's also an issue with the Pennsylvania Wiretap Act, if you haven't told anyone you're doing it. So there was clearly a multiple level problem at that point.
Right, and that's something that actually came up quite a bit during the pandemic. I think people were quite surprised because there was in some respects easier, at least more convenient press access to a lot of proceedings because you just sit and be on Zoom. And I think there was an assumption that, well, this is public, this is being publicly aired, I can record it as well. And that turned out not to be the case under the federal rules. And there was a decent amount of litigation.
And under the state rules. I mean, because the number of state judges opened up their courtrooms for Zoom proceedings, but again, not permitted.
And again, to give you a sense of how varied this practice is, in the Florida proceeding that I mentioned earlier, and I have another proceeding right now in the same court, every single proceeding is live streamed on Twitter and recorded, and multiple journalists will sort of put the entire proceeding up on Twitter and take screenshots and make fun of the attorneys and things like that. It's the practice varies wildly across different jurisdictions. Although federal practice will definitely prohibit that. Melissa, did you have questions or did you want me to proceed? Okay. So I think you may have touched on this when you said you haven't had a proceeding yet that's sort of been so crowded that the press is clamoring to get in. But do you have views about whether you would permit the live transmitting during a proceeding of information?
No,
Just
not. It's against the local rules.
you would not. Okay. And this is a major issue for journalists, just because the media environment today is no longer you go to proceeding, you think about it, you write your story, and you file it hours later. The expectation is that there'll be the live transmission of information either on the publication's website or through Twitter. But I interrupted you, but your response, Judge Beadlestone, is
well, I wouldn't, because as I said, it's not permitted by the rules. But here's the bigger problem is that because I don't know. It's situational rather than a problem. So I have had all this year. I've had many high-profile cases, and in fact, I dropped an opinion yesterday and one 2 weeks ago. If you read what the press is writing about what my opinions say, they've got nothing to do with each other. Nothing to do with each other. And what I say, I hope, is very considered, responsive to the parties' arguments, grounded in a legal analysis. And yet you read the press reports, and not all, but many, their view, as I said, something totally different than what I actually wrote. And I think that is very frustrating for judges because, particularly in an environment where we're being attacked for all sorts of things, if there is a report which says something about one of our opinions, which is in fact entirely incorrect, and we often rule in culturally, sort of the culture war areas. And what happens is that then rolls over into social media, and then we go into this insane social media response to what people think we have said. And that increases the danger to the judiciary and also undermines the authority of the judiciary. So the press has a key part to play in ensuring that the rule of law continues to be strong. In my view, the rule of law is a critical component of democracy. So in not reading decisions properly and not understanding the legal environment in which that opinion was written, I think Judge Kearney said a little bit about this in the last session, you're actually failing as a journalist, and you're failing in your job to make sure that people are aware of truth and what is happening. So I think that if you are going to cover high-profile cases, or if you're going to cover any kind of case, just make sure you get it right. And I don't know whether journalistic organizations now allow people to focus just on legal issues, but that is something that is helpful, because then the journalist understands that it is an environment that is different than in other circumstances, and make sure that they write their stories with regard to that difference.
The journalists are typically not going to have legal training or legal background. They may, throughout their, despite their best efforts, not fully understand that a motion to dismiss is not a ruling on, the final merits or that sort of thing. My understanding is you do not want to be fielding calls from journalists saying, what does this decision mean? What was the procedural posture? Am I correct about that?
No, but I do when I write my opinions, particularly when I know that they're going to be read by the public. I try to make them as clear as possible. I think that there's some sense that, oh, the law is so complicated, and the more opaque the legal writing is, the more intelligent it is. That is not the case. I try and write things so that a member of the public can read it, and maybe they don't understand it the first time around because it is complicated. But my hope is, and my focus is, trying to write opinions so that not only members of the press who do this all the time, but also members of the public who might be just interested in a particular case will understand not only the procedural posture of the case, but also the substantive issues that I address.
Right, and the other thing I would add to that, to the journalists, is that it's always good to reach out to the attorneys on a proceeding. In my case, I will almost never give an on-the-record statement, but with client permission, I'm willing to sort of answer on background questions about, well, this is the procedural posture, this is what that means. And then you should also have, hopefully, access to some, law professors love to talk in the press, and you should have access to sort of a Rolodex of sort of legal experts that can sort of answer questions. And obviously sometimes you can use them as a way to sort of say things about the case that you can't say in your own voice, of course.
I'd also make a suggestion that you could turn to local bar associations, that they may be able to help, you understand what the law is, what's going on in court. Like there are a number of resources, not the judge, but there are a number of resources that press can reach that may take the call.
And I'm
Listen,
one of those
yeah.
resources. I talk to journalists all the time who call me and say, this is what is in this court order or what's in this opinion. What does it mean? And I focus on First Amendment media law and related areas. So if they call me about a murder case, I may not be the best resource for that. But what I can do is send them to, a colleague of mine, or the Pennsylvania Bar Association has what's known as its media response team that connects journalists with questions on various areas of the law. And I send, questions about, what does it mean to be death penalty certified here in Pennsylvania court? I don't know the answer to that, but someone on the PBA, the Pennsylvania Bar Association's media response team, will, and they've already agreed to be the contact for journalists with those kind of questions. So there are resources that are available to you as journalists. You just kind of have to, and I'll drop the link to the PBA and my organization in the chat as well, so that you can have those at your fingertips when you need them. And there are others as well, including the Reporters Committee for Freedom of the Press, lawyers for journalists. There are many organizations out there, including mine and including the Pennsylvania Bar Association.
Another issue that Judge Beaglestone we talked about yesterday, but I'm curious for you to articulate on. So one of the frustrations, at least in civil cases, that media lawyers have is that court filings are routinely filed under seal through the consent of the parties. It's a business dispute. The parties decide, sort of almost a sort of mutual disarmament pact that they'll agree to sort of have the purportedly sensitive business information be filed under seal. And the result is you look at some dockets and just everything is under seal. And I confess that sometimes I will do the same, when I represent clients. But what is your approach to sealing issues when there isn't a member of the press to sort of stand up and say, Your Honor, I object to this being under seal?
Well, there's really two access points into having documents sealed, and possibly more, but two I can think of right now. One is that the parties have a confidentiality agreement in place, and they've asked the judge to sign off on it, and the judge has. The second is on a specific motion, the parties have asked to seal the motion. So let's start with the confidentiality agreements. I think that until fairly recently, it was routine in our court for many judges to just, if there was a confidentiality order that was sent in, they just signed it. There was a case called Pansy, which really said, no, you shouldn't sign it. But and there were also some other cases, but I don't think that there was really a focus on what the Third Circuit law was at various stages of the proceeding. And then there was a case called Avandia, which made it crystal clear, the Third Circuit made it crystal clear how things should be dealt with at various stages of the proceeding. So the first is discovery, and discovery is just when the parties are sending off information and documents to each other, and the court is not involved in that for the most part. If the parties don't do what they're supposed to do, the court can get involved, but generally it's just the parties exchanging information. Avandia says with respect to that, the parties can do whatever they want because it's really not in the boundary of the court at that point. The next point is when the parties file documents in the court in support of their motions or possibly even their complaint. That is different because now we're dealing with the First Amendment and the common law right of access. And so the question is, can the parties agree in these confidentiality orders just to file everything that they have determined is confidential during discovery? Can they just file it under seal? And the answer to that is no. They have to ask the judge whether they can file a particular document under seal. And they can't just say, here is 5,000 documents and we want them all sealed, because I have to look at them and I have to make a determination as to whether a particular document could be filed under a seal. There are lots of reasons. For example, if there's a trade secret, if there's information that is that competitors should not know, but it's not just, you can't just say, oh, it's business secret. You have to really tie it into a case that says this kind of information should be filed under seal. There are some things that it's absolutely obvious. So a social security number, the name of a minor, that kind of stuff. I will immediately sign off on those things. But with respect to business records, there's an analysis that has to be done. With respect to that, if the confidentiality orders that people provide me include a right to seal, I will say I will not sign this as long as it has that information in there. Also, the burdens, who bears the burden of determining when something should be sealed and when it should not be sealed. And often in these confidentiality agreements, the lawyers will set forth the burdens, they'll negotiate the burdens between them. My view is that is not their job. It is my job to determine who bears the burden. And so I ask them to get that out of the confidentiality order. So in essence, before I will sign a confidentiality order, I will make sure that they are in compliance with Avandia. And I will say I will only sign it, and I get my deputy to send off the judge will only sign if you remove paragraph 9 and the second sentence of paragraph 10. Then I will sign it. So at that point, we have the confidentiality order in place. There may be a request. I have to evaluate that request, and then I say yes or no. Now, when you get to trial, the whole situation changes again. And I tell people in the Rule 16, and remember that was the first conference I have with people when we're just sort of sorting out what this litigation is about. I say, once you get to trial, we have public access. The court is going to be open. And to the extent that you have determined that something is confidential, even highly confidential, and even if I have determined that it should be filed under seal, the presumption, and the heavy presumption, is it's an open courtroom. And if you bring it and you put it up on that screen, whoever's in the courtroom can see it. So that's, I think I addressed your question, but if you think there's little bits and bobs that I need to go further in, I'm happy to continue to talk.
Yeah, it was very helpful. And we just in general sort of always tell our clients that when things go to trial, all bets are off, that to the extent that you're counting on the ability to keep information confidential, that goes away when things go to trial.
Yeah.
So the additional thing I was just going to add, and maybe you can comment more on it, Judge Beetlestone, but so the non-lawyers here, the way our legal system, as you know, is structured, is it's structured in an adversarial way. So typically a judge is not making her own arguments on behalf of the parties, but is simply responding to the arguments that are being presented to her. The press access issues to some extent are special simply because, there are rights that the public has to proceedings. And sometimes, less so these days with budgets for media organizations being what they are, there will be lawyers to advocate on behalf of the press, but often it will fall to the judge to sort of, police the proceeding to make sure that the interests of the press and public are being, effectively accommodated. Judge, can you talk a little bit about your understanding of those obligations?
Well, I think there are some instances where it's clear that I do have an obligation to really focus in on what the class actions, for example, I have to really focus in on what is good for the class. In terms of, I think your question is about the press, and my my entire focus is really on Rule 1. Which is I have to make sure that there's the efficient administration of justice. And there's a lot of words in there. Efficient could mean fast. It could mean making sure that it is done in such a way that all interests are protected in an efficient manner. It also is justice. So what is justice? So I would imagine if I was in a situation where a journalist got up and said, there's a First Amendment right here, It's possible that they could be wrong, and if I know that they are wrong, I will rule immediately from the bench. But if there's a possibility that they could be right, I think I would look at the question, even if they weren't represented. I would also suggest to them that they get a lawyer so that they can, because just a journalist getting up and saying I want does not necessarily mean they will get. And there's a higher likelihood if they hire an attorney to intervene and say, I want, and here's the 5 reasons why. Obviously, that's now I have some meat in front of me that I can evaluate and deal with, rather than having to think through very quickly the issues by myself.
So the last question I wanted to ask is about sort of cameras in the courtroom. As you mentioned earlier, you have absolutely no discretion over that issue, and in federal court, that is very much taken out of your hands. But as you know, sort of some jurisdictions do permit it. I speak from my own experience. I've done 2 trials that were live streamed. My sense is that psychologically, it's very hard on the attorneys to know that everything they're doing is being watched. You find yourself in a way you shouldn't, sometimes looking at YouTube comments about your haircut, about your outfit and things like that. But when you're actually sort of there at the podium talking to a witness and talking to a judge, you don't think about it at all. You're just focused on what's happening. What is just thinking through your experience as a judge, what is your sense of how that would change things if there were cameras and that a proceeding was being live streamed?
Well, think about cell phones, and I bet you everyone here has taken a selfie, right? Put your hand up if you've taken a selfie, right? Debbie, you've taken a selfie, right? Right. And I will tell you a story. Last summer, my youngest child said, "You don't know how to take selfies, Mom, and you can look better." And so they spent like half an hour teaching me how to do a selfie. So now the selfies that I do look much better than they did before, and it is artifice. So once you have an image, either if it's an image broadcast, suddenly you are in a different situation. Suddenly you're trying to put your best foot forward, and maybe suddenly you're being a little dramatic. If you have a high profile case and you know that it is going to hit all the way across America, one, you're a little nervous because you want to make sure that your arguments are good and your attention is going to be focused on that question rather than the questions that the judge is asking. And in fact, the judge may ask a question, but you would prefer to have a good soundbite rather than answer what the judge is asking you. So that's problematic. And in essence, what it moves from a situation where everybody is doing their jobs to move this thing forward to everybody suddenly has an eye on the exterior. Perhaps the judge is interested in, certainly the judge wants to come across well, wants to come across as someone who is thoughtful and considered, and maybe they pull their punches on something, or maybe they don't. Maybe they push a little bit more or something. Maybe the plaintiff's lawyer is someone who's trying to build a reputation, and so therefore maybe a little bit more flamboyant than they otherwise would be. So whether or not you think that is a good thing, what happens is the control in the courtroom, which is critical for cases as they move ahead, spins out. So suddenly, I mean, we all remember the OJ trial, totally out of control, and it was because everything was being seen by everybody. I mean, it was a circus. And so I think it's not a good idea, and not because it's a bad idea for the media to have access to proceedings. I think that is a good idea for the media to have access. Of course, it's a good idea. It's critical for our democracy. But when you put something in place that it is going to destroy the solemnity of the proceeding and the job that needs to be done, then it's problematic.
So I know our time is coming to an end, but there has been a question about the difference in open proceedings, I'll say, with minors or victims of domestic abuse, and I didn't know if you wanted to address that question.
Melissa, do you want to?
Sure. So it depends on what kind of proceedings you're talking about. I mean, we have in Pennsylvania state court, we have state law, we have the Juvenile Act, which makes most proceedings and records related to juvenile delinquency and dependency proceedings off limits or closed, although the presumption of access has been found to apply to some dependency proceedings. So if we're talking about cases that are being decided under the Juvenile Act, you're going to have very limited access to both proceedings and records. If you're talking about how a judge is going to have a child witness on the stand, for example, as the victim of abuse, or if there's a victim of physical sexual abuse, an alleged victim, there's a statute statutes in Pennsylvania that say minor victims of physical or sexual assault, the records that reveal their identity, you don't get access to their identity. The same applies to sex trafficking victims and in certain situations. With regard to proceedings, in my experience, and I'm going to obviously defer to the judge from her experience, when my judge was on the bench, it would depend on the child, him or herself. Some of the children wanted to address everyone in the courtroom, including their alleged abuser. Others preferred to have it in chambers. It's going to be a case-by-case basis, but the presumption is it's public unless and until a judge finds good cause to remove some aspect of public access. Is that consistent with your experience, Judge?
I would say it's a case by case. I think that's what you said. It's case by case determination.
Okay, thank you. Thank you all so very much.